Hello, everybody, and welcome to History/Law Bite number 142, dated December 27th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled The Fugitive Slave Clause of the United States Constitution. Many Americans, in spite of knowing that slavery existed in this country, are completely unaware that the U.S. Constitution contains a now, of course, obsolete Fugitive Slave Clause. The clause was intended to prohibit slaves from attaining freedom merely by virtue of escaping from a slave state to a free state, though that was typically easier said than done. The clause officially required those free states to turn fugitive slaves back over to their owners in the slave states. But of course, knowing history, we know very well that that did not always occur. All right? So, let me read to you the Fugitive Slave Clause, again now obsolete, in the U.S. Constitution. You can find it in Article 4, Section 2, Clause 3. It reads as follows: No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. So that is the Fugitive Slave Clause of the U.S. Constitution. And in essence is saying that no person, because, remember, they did not want to use the word slave or slavery, so they said no person who is being held as a slave in one state, okay. This also, of course, is referring to indentured servants when it says labor, all right? Held to service and labor, they had to include both slaves and indentured servants as well. But for all intents and purposes, indentured servitude was gradually phased out, all right? And this clause primarily speaks towards fugitive slaves. But of course, the language is very, very much applicable, at least was applicable in that time period, to indentured servants as well. So no person who is held as a slave, all right, in one state, under the laws of that state, okay, and escaping to a free state, okay, shall, as a result of the laws of that other state, be discharged from their state of slavery. Okay, but instead shall be delivered to the person whom they escaped from, if that person comes to look for them in that free state. All right, that's basically what the Fugitive Slave Clause is saying. Okay, this clause almost didn't make it into the U.S. Constitution. As a matter of fact, it was introduced by delegates Charles Pinckney and Pierce Butler of South Carolina, all right? They wanted this clause in the U.S. Constitution to ensure that their human property, should it escape, okay, into a free state, legally have to be returned to them, all right? If their human property escaped, let's say from Maryland all the way north to Massachusetts, the Fugitive Slave Clause would obviously require Massachusetts, all right? If the slave owner or bounty hunter came up there looking for that slave, they would have to turn that slave back over to their owner in Maryland, all right? And so this is certainly a nationally enforced law, a nationally enforced part of the Constitution, rather, okay? So Butler and Pinckney introduced this clause during the Constitutional Convention of 1787, and it immediately drew outrage and protest from many Northern delegates who asserted that if we put this trash in the Constitution, that it will require us Northern states to enforce slavery at the public expense. All right? The two primary opponents were Delegate Roger Sherman of Connecticut and James Wilson of Pennsylvania. All right? So as a result of the opposition, Pinckney and Butler dropped the idea of the clause. It was soon reintroduced once more, and unfortunately, it passed without objection. So that means, like many things at the Constitutional Convention, if the Northern states had just pushed back a little more, okay, this trash known as the Fugitive Slave Clause likely would not have been in the Constitution, all right? And Butler and Pinckney wanted this in the Constitution as well because under the colonial period, all right, while we were still under British rule, as well as during the period of the Articles of Confederation being in effect, the Confederation period, Southern slaveholders had no recourse whatsoever to obtain their human property if it escaped from their states into free territory. All right? If a slave in Virginia escaped all the way to Philadelphia under the Confederation period, or while we were under British rule, guess what? The slave owner was out of luck. Tough, too bad, so sorry. All right? He was just out of however much money that slave cost. All right? So there was no recourse. If your slave escaped, that was it. If you didn't manage to apprehend them somehow, you were just SOL. All right? There was no legal recourse to acquire a runaway. All right? And the Fugitive Slave Clause here in the U.S. Constitution specifically put an end to the absence of such legal recourse, requiring, all right, free states to turn over fugitive slaves if the owner should come to those free states and present a claim demonstrating that that slave belonged to them. All right. But like I said before, that didn't always happen. And as a matter of fact, Northern states presented a great deal of obstacles to Southern slaveholders in trying to obtain fugitives. Okay. We see a significant amount of obstructive laws enacted in border states like Pennsylvania, all right, and New Jersey, all right, and Ohio and other places that bordered free states, okay. These places made it difficult to acquire and, shall we say, take back alleged fugitives into slave territory once they were on free soil, okay? And as a matter of fact, many of these free states made it a felony to try to do so. Now, of course, in a strictly legal sense, that was illegal because the Constitution required that the free states turn the fugitives back over. Okay, you can understand why they didn't want to turn the fugitives back over. But from a strictly legal sense, of course, I'm saying I don't agree with it. Obviously, I'm just saying in a legal sense, the free states' laws obstructing this was unconstitutional. And we see that bear its full head in the case of Prigg versus Pennsylvania, which I covered in another video. All right. And the Supreme Court, of course, struck down Pennsylvania's laws obstructing the ability of slave owners and bounty hunters to come into the state and present evidence that the escaped slave belonged to them, and thus prohibiting them from taking them out of the state. All right. So what I'm saying is Northern states, in spite of Prigg versus Pennsylvania, all right, and in spite of the Fugitive Slave Act of 1793, which was designed to enforce the Fugitive Slave Clause, further reinforced by the Fugitive Slave Act of 1850. These laws didn't make any difference. Northern states still obstructed slave owners from the South from coming into their states and kidnapping blacks. A great deal of them who were free, all right? They often presented very faulty evidence, if any at all, to demonstrate that these black people that they were taking were in fact former slaves, all right? And quite often, many blacks were simply abducted, Forget the law. They would kidnap them at night and you'd never see them again. All right. So, individual states certainly made it very difficult for Southern slaveholders to come into their states and abduct African Americans to take them back to the South. All right. But the normal procedure, as required by that Fugitive Slave Clause, like I said, was if a Southern slaveholder or a bounty hunter sent by them, sent to a free state to apprehend an alleged escaped slave, they were just supposed to present some sort of evidence, to the local authorities in that state, and the free state was supposed to turn the fugitive over. Like I said, quite often that did not happen, all right? And quite often these northern states would arrest these bounty hunters and slave masters for attempting to abduct, or even in the legal means, with presentation of evidence, trying to take the blacks out of the state at all, okay? Northern states made it very difficult, okay? And that's why the Fugitive Slave Act of 1850 was passed. It was a very evil, draconian law, pushed by the South to force northern states into compliance to support slavery, whether they wanted to or not, okay? And so all of these things, these tensions would lead to more and more division in the United States, ultimately, of course, taking us to the outbreak of the Civil War in 1861, all right? So the slavery issue, supported by things like the Fugitive Slave Clause, the Fugitive Slave Act of 1850, the Dred Scott decision, all of these things, serve to fuel sectional tension in the United States. The North versus the South is the sectional tension, of course, I'm referring to, leading, of course, to the breakup of the nation. All right. Slavery issue arguably was the most divisive one in American history. It is one that America hates to face, but it is one that it must face and acknowledge. It is a very vicious and cruel truth, but one that has to be understood. Okay? So that, folks, is the Fugitive Slave Clause. All right? That clause was, of course, rendered entirely obsolete and useless by the 13th Amendment to the Constitution, which forever abolished slavery and involuntary servitude, except as a punishment for a crime in which the party shall have been duly convicted. All right? So that's the Fugitive Slave Clause, ladies and gentlemen. Any questions or controversies, you can leave them down below and I'll be happy to answer them. Okay? Thanks so much for listening to this History Bite. I appreciate you. I love talking about these things. If you have not subscribed to my page, just please hit that little red subscribe button and that little bell and we'll be in business. Okay? We love to teach over here. Okay? And your support in helping me continue to teach is always and most graciously appreciated. Okay? So I thank you again for listening. Take care. Stay safe out there. And I will talk to you at the next bite. Peace.